We mentioned before this break State v. Odom, and let's talk about State v. Odom because that case really became a pivotal point in your career. Tell us about that case.
State versus Odom was a capital case, which the Tennessee Supreme Court heard the first time back in late 95, 96. It was a horrendous factual case. It involved the murder and rape of a more than 80-year-old woman who had been visiting her doctor for an examination and who was accosted when she entered her car in a parking garage. Mr. Odom was tried and convicted of capital murder, and the jury in the subsequent penalty hearing in the capital trials have two phases, both first the guilt and then the penalty hearing, was sentenced to death. The appellate issues that came before the Tennessee Supreme Court, the ones that are most relevant to this discussion, involved an evidentiary ruling that the trial judge made in the sentencing or the penalty hearing, in which the trial judge excluded testimony by Mr. Odom's psychiatrist. The issue in a death penalty sentencing phase is whether the aggravating circumstances, which are specified by law, outweigh any and all mitigating circumstances, which are not limited by law. The Constitution mandates that they not be limited by law. And in a sentencing proceeding in a capital case, the statute also specifically relaxes the evidentiary rules and in particular allows the admission of hearsay. The trial judge disallowed the psychiatrist from testifying in the penalty phase under the theory that it would be hearsay because he had talked with Mr. Odom and other members of Mr. Odom's family in order to arrive at his opinion. With all respect to the trial judge, I usually describe that ruling to my evidence class as an evidence error so egregious that a first-day evidence student wouldn't make it. For one reason, experts are always allowed to rely upon statements of others that they use in determining their diagnoses. And for another, the statute clearly allowed the admission of hearsay. Be that as it may, the trial judge excluded that evidence. So on appeal, Mr. Odom's again, relevant to our inquiry, Mr. Odom's lawyer argued that that evidentiary ruling was error, that it therefore deprived Mr. Odom of his right to put into evidence mitigating circumstances and therefore affected the balance that the jury would have to make in weighing the aggravating and the mitigating circumstance. And the more purely legal question, which divided the court 3-2, was whether, in light of all the evidence in the case, the state had satisfied its burden of proving that the murder fell under the aggravating circumstance that's known as heinous, atrocious, and cruel, so-called hack aggravator. So the Justice Birch authored the Odom opinion, in which three of us agreed that the evidence as presented was not sufficient to prove the hack aggravator and that the evidentiary ruling was an error and therefore remanded the case for a new sentencing. The lawyer had, as is always true in capital cases, argued for the complete elimination of the death penalty on constitutional grounds, had also argued for the reversal of the conviction of Mr. Odom. So really, in some ways of looking at it, the remand for a new sentencing hearing was a fairly modest victory, if you want to use, if victory has any place at all in a capital case, if you want to use that word. But nonetheless, it was a ruling that resulted in the state having to try Mr. Odom's sentencing again, having to go through the sentencing again. The other aspect of the Odom case that fits into the analysis of the heinous, atrocious, and cruel aggravating circumstance is that the state bore the burden of proving that by legislative dictate. And because capital cases are to be reserved for the most compelling of murder cases, what the U.S. Supreme Court sometimes refers to as the worst of the worst, it is not true that every vicious murder necessarily is appropriate for a death sentence. So in attempting to say that in the majority opinion, in hindsight, I now think that we should have been more careful, because what Justice Birch said was, this case does not fit within the worst of the worst. Using that phrase that capital lawyers know, that judges know, but that does not communicate well with the media or the public, particularly when you are talking about a person as innocent as Ethel Johnson, and I did not look that back up last night, I'll never forget her name, the victim in the case, as innocent as she was, to say this is not the worst of the worst is not, it's just one of those places where legal jargon and lay jargon don't coincide.
It was a term of art that didn't really fit what the public would perceive as being the right definition.
And it made for a good headline. And so many, and I emphasize that for a reason, weeks after that opinion was released, the Nashville Banner began a campaign, I don't know any other way to characterize it, to oust me based upon that decision. And one of the early headlines said something like, "Court holds rape murder of elderly virgin is not cruel." And I am almost precise in that memory of that headline. From that day, from that beginning on, it was an onslaught against me for the 6 weeks that remained from that Odom decision until my retention election, which was set for August 1st, 1996.
You say the newspaper began a campaign to oust you, and yet you were not the author of this opinion in which 2 of your colleagues joined. Am I correct about that?
That's right. And that's why I emphasize that this happened weeks after the Odom decision came down. Ostensibly, what drew the media attention was a petition to rehear filed by the State Attorney General's office. I say ostensibly because there are a lot of things about those 3 months in 1996 that remain a mystery. There are some things that seemed one way in 1996 and that now I clearly know were not. But that was ostensibly what brought it to the newspaper's attention. The point I'm making is that when the case came down, there was no media attention whatsoever. So, I mean, you asked me about the case, and I unfortunately, for the people involved in the case, jumped into a discussion of how it affected me, and that's a bad thing that I just did, because the case itself obviously has its own actors and its own victims and people that is important and significant, separate apart from how it played into the 1996 retention race. But we remanded the case for a new sentencing based upon those 2 rulings, which basically meant, and I think this is important, and it got lost, a lot of the details of Odom got lost in the media's rush. But what it means when you remand a sentencing for a capital case, and when you tell the state, 3 of us don't think you've sufficiently proved the hack, what that means to any good lawyer is, hey, I better scramble a little bit and get a little bit more evidence together before this new hearing. In many ways, the Odom decision was a map for the district attorney to do it right the next time. We didn't say no death sentence, we're going to sentence this man to life. The court has done that on occasion. We could have done that. Or we didn't say the death penalty hack is unconstitutional. Many states have ruled their heinous, atrocious, and cruel aggravating circumstances unconstitutional. We didn't do that. We were asked to. We didn't. So in most ways, it was a very modest decision. And that's why you have to look at it with the vision of post event history and realized that Odom was nothing more than the most convenient vehicle those who wanted a seat on the Supreme Court could use to get one. And I say that very carefully. I'm not saying those who wanted rid of me. I am not so vain to think that I personally had anything to do with it. All I had was a seat, and it was the easiest and quickest seat to get because I was standing for retention and no one else was.
Now, that brings me to a point, because this is a history project, and we're not sure in the future exactly what the situation will be in terms of what the procedures are at the time somebody is viewing this. Could you explain briefly what a retention election is and how judges would get ousted at the time you were ousted?
Yeah, so the retention vote in Tennessee requires that one more than half of the number of people who vote yes in order for a judge to retain their seat. So whenever the election term is up, or whenever the judge is standing for retention, the ballot reads, should Justice White be retained as an Associate Justice of the Tennessee Supreme Court? And the voters vote yes or no. And in Tennessee, the rule has always been that it takes just one more than 50%. Some states impose a higher percentage than that, actually, but we don't. So on Election Day, voters vote yes or no. And based upon that vote, a judge is either retained or not. I was sitting in a unique position because I was the first, what I'm going to call, not with any intended compliment to myself, but under the common way that it's called, I was the first merit-selected judge to stand retention. Now, Justice Birch had stood retention, but he was not merit-selected. Justice Birch was appointed right before the Tennessee Plan became applicable to states, to the selection and the filling of vacancies for state Supreme Court justices. So I came onto the court via the Judicial Selection Commission and the so-called Merit System Tennessee Plan. And then I stood for retention as quickly as I did because I was filling out an unexpired term. And in Tennessee, if you're filling out an unexpired term, by law, you stand for election or retention, depending on which position you hold, at the next general election. So since I went in December of 1994, I stood on August 1, 1996. The other perfect storm part of my situation is I was the only judge on the Supreme Court to stand on that day, so it was the only name under Supreme Court. And the other, benefit was I was easily distinguishable because I was the only woman. And at that time, I was young. I was younger by 20 some years than my youngest colleague. So I was very identifiable. And so that was the process. And I think that's one of the, I think my defeat is one of the most important advertisements for retention elections, because it proves that if you want rid of a judge, you can get rid of a judge. Those who tout elections, partisan or popular elections, rather than retention elections, often argue that retention elections are such down ballot, they sometimes call them down ballot or low voter interest races, that everybody gets retained, and so that they're tantamount to a life appointment. I'm exhibit number one that is not true. We now have at least a dozen exhibits, including the 3 members of the Iowa Supreme Court who were not retained 2 years ago. We have Justice Lamphere in Nebraska. We have the 3 members of California. Certainly, though, that's not a lot of examples, but you can remove a retention judge. And I would argue that it is harder to run against nobody than it is to run against somebody. I got beat because people believed that anybody would be better than me. I could not contrast myself with some other candidate who might be less qualified, who might have skeletons in her closet or his closet. I had to run against nobody. And I like to tell people that, I managed to lose to nobody. But the truth of the matter is that a retention race is sometimes harder to win than a straight-up race. So these people who claim that retention elections are bad because they're the equivalent of a life appointment, I think that's a bogus claim.
So, in the ideal, the way retention elections were designed in Tennessee at that time was you go through a merit selection process, you're serving a term on the court, which is an 8-year term.
Right.
And then at the end of that 8 years, the voters decide whether they want to retain you as a judge or not. But because you followed Charlie O'Brien and filled in for his last 2 years of the term that he was on,
That's right.
you immediately came up for a retention election before anybody really knew who you were. Is that fair?
Yes, that is fair, and I think it's. I think we have to let's get the historical record straight. No one had ever been challenged. Although the Supreme Court had not been a retention court, the Court of Appeals had always been retention courts, or at least in recent history had been not always. I won't say that, but in recent history had been retention courts. No judge who was a retention election judge had ever been challenged. It was so accepted that a judge would be retained that judges did not have treasuries. When the attack against me began on June the 13th, and I'll never forget that day, 1996, I did not have a treasurer or a treasuree. No one anticipated that I would need to run a campaign, and it was so unheard of that we thought it was basically unethical for a retention judge to run for their retention. So at that time in history, none of our justices would be so ill-prepared today because, fortunately for them, I've prepared them. They know better than to get caught, get blindsided. But at that time, it was completely unexpected.
At what point did you recognize? Was it when that Nashville Banner article came out? Did you realize immediately then that you may be in trouble?
Well, yeah, in fact, and this is also kind of goes back to the code of the hills or the culture of the hills. I am a very worrisome person. I look for things to worry about. One of my friends tells me I will get the gold medal in worrying. So I was worried long before that paper, to the point that I had voiced it to my colleagues and that I had sought advice from a law firm that did some political consultations in Nashville to be prepared. And everyone said the same thing to me: you have nothing to worry about. Don't worry about anything. You have nothing to worry about. When the first newspaper hit, and I think this is a story worth repeating for history because it's funny given the world we live in today, but the court was at Park Vista, what was then the Park Vista Hotel in Gatlinburg, along with the entirety of the Judicial Conference in the mandatory June Judicial Conference meeting. And we had a mixer with the TBA of some kind here in Knoxville, and we had driven from Gatlinburg to Knoxville for that mixer and went back up the mountain. And when we got back up the mountain, I had a voicemail from Sue Allison that said,
Sue Allison was?
Who was the then press agent or public relations person for the court. And she said, Justice White, they've started a Just Say No campaign. I don't know the specifics, but I'll get with you in the morning. That was a Wednesday night. That Thursday morning, it was Thursday night. That Friday morning, the five of us, Justices Drewota, Anderson, Reed, Birch, and myself, were gathered at the coffee station at the Park Vista awaiting Sue's trip to Knoxville to find a paper, to bring it up there to show us. We had no idea what was involved, what case I was being criticized for, we knew nothing. We were completely oblivious to what, well, let me put it this way. I was completely oblivious, and if any of them had I know them, and I know their integrity, and I believe they would have told me if they had known. None of them let on that they knew anything. So the paper comes up and we see what and again, as soon as I say that, I'm thinking, well, here's my naivete coming back out. Maybe they did know in the backs of their head. Maybe some of the judges, maybe Justice Anderson or Justice Drewota knew, and in the back of their head they were thinking, boy, this is going to come down on those three, but nobody ever spoke that if they knew it. And I have reason to trust that they didn't know that. But in any event, the paper came and we saw the headline. And that very day, then Judge Wade was leading an assault on Mount LeConte with a number of us. So we look at the paper, and my insides are churning inside out, and I went and I climbed Mount LeConte that day and worried about it all the way up, talked with him about it, and talked with a lot of people who were doing that hike. And the common thread was, it's a one-day story. It's a one-day story. I have to say that I had the same sinking feeling I had earlier that year when I had sought consultation with a firm with political expertise. I didn't feel it was a one-day story. If you asked me on that day, did I think I was going to lose? I knew it was a possibility, but it just became really clear after the media would not let up. It was not a one-day story.
Sue Allison came and said they've started a Just Say No campaign. Who was they?
Well, it turned out that they was the Tennessee Conservative Union, comprised of two gentlemen in Chattanooga who took most of the credit for it. At least that's who the they was. But in reality, Charles, history and research have helped me to learn that they were just the front guys. They were the Republican Party. They were the new Sundquist administration. It was the Sundquist administration desire to have a seat on the court, and my seat was the seat to get. So the Lloyd Daughtry's and the John Davies, who were the Tennessee Conservative Union, were being manipulated in the same way, in my opinion, that the voters were being manipulated. They were out front doing the work for the administration.
Pure political battle.
Complete, nothing but politics. And, talk about not meeting people. The three people who campaigned the hardest against me, the governor and the two United States senators, had never met me and had never had, as far as I know, had no idea about who I was or what I stood for or what service I had given to the state. Yet they all felt very comfortable in telling the voters of the state that I didn't share their values. And that was a real eye-opening political experience.
Hurtful to you today?
Oh, to this very day, as if it's not obvious. Yes, very hurtful.
Once the battle was joined and the battle was well and truly on, did you feel like you were wearing some handcuffs because of the Code of Judicial Ethics? I
did not consider them handcuffs, but I did feel that my conduct was dictated by the Code of Judicial Conduct. Our code at the time said two things. First, it said that a judge shall not comment on a pending or impending case. And secondly, it said a judge shall not announce views on a contested political or legal issue. It is so ironic that and let me wander here just for a moment to come back. Well, let me talk about the code and then tell you why it's ironic. So now, the part of the code that says a judge shall not comment on pending cases was changed. Really, in 1997, our court changed it to say may comment on a pending case so long as it's not likely to affect the outcome. But the time I was on the bench, it said shall not comment. And I really did feel like a role model. I felt like it would be really wrong to stand up as a judge on the high court of a state and violate the very fabric of that institution's integrity. So I took that very seriously. I took that shall not as a shall not, and I did not comment on the case. The other part of the rule, the other part of the code that played in, the announcing the your views, what consultants told me is, can you say you support the death penalty? Will you just say that? If you will just make an impassioned plea to the voters that you support the death penalty, we can save you from this. That part of the code also said you shall not announce your views. At one time, the closest I ever came, and I didn't feel that good about this, but the closest I ever came to announcing a view is to say, I took an oath as a justice of the Supreme Court of the state of Tennessee to uphold the law. The law of the state of Tennessee includes certain processes for capital punishment, and I have taken an oath to uphold that law. I did say that. I did not say I believe in capital punishment. A lot of people would say that I did not say that because I did not. And here's where the irony comes in. Because I did not believe in it. Here's where the irony comes in. My opponents, the people who took me off the Supreme Court, made me oppose capital punishment. I had tried capital cases, and I wasn't fond of capital punishment, but I had crossed that bridge before I became a member of that court. I knew that the day would come when I would have to apply the death penalty, and I had accepted my obligation to do that. What made me an opponent of the death penalty was seeing how it can be used and was used to completely politicize the judiciary. So I have become an outspoken advocate of reforming death penalty processes and of eliminating capital punishment because of my election, not before my election. And the other irony is that very judicial code provision that says you shall not announce views on political and legal issues is the code provision that went to the United States Supreme Court in a case called Republican Party of Minnesota versus White, not me, obviously, Suzanne White, the director of elections in the state of Minnesota. That case went to the United States Supreme Court being challenged as unconstitutional, and the United States Supreme Court found that that code provision violated the First Amendment and that judges should be free to announce their views. And that decision was the beginning of the complete destruction of state courts that we are living in the midst of today. And to me, that's just very ironic that all of those sort of things would come together in one person's life. So I did not speak out much. I did not campaign much at all. I didn't have the money to do that. But I don't think all the money in the world in '96 could have combated, I don't know, maybe I'm selling advertisers and media people short, but I doubt it could have combated the anger and the hatred and the ire that the media created against me in 1996. I often said I couldn't get elected if I pulled the switch on the next execution because of the hatred that was out there.
You sat for 2 years on the Court of Criminal Appeals and for 2 years on the Supreme Court. Did you ever have a case where the death penalty was upheld?
Yes, on the Court of Criminal Appeals. The case, the Odom case was the first direct appeal death case I'd ever sat on. So let me just explain that very quickly. So in a capital case, after the conviction, the first appeal is the direct appeal. And at that point, when I was on the Court of Criminal Appeals, all direct appeals went straight to the Supreme Court. So I never had the occasion to sit on a direct appeal at the Court of Criminal Appeals. So Odom was the first death penalty case I ever sat on in that sense, which is another interesting fact, how people would know my opinion and that I was an advocate against the death penalty when I never sat on a direct appeal before. However, on the Court of Criminal Appeals, we did have post-convictions. So after a capital case is upheld, the convicted and sentenced, the convicted death sentence inmate will petition for a review post-conviction, generally alleging newly discovered evidence or ineffective counsel or sometimes prosecutorial misconduct, something like that. I'd sat on those cases, had two. One of them we had upheld a death sentence. The second one, the other one had been remanded on some procedural issue, but it had not, I had never obviously sat on a case in which we had either found the death penalty to be unconstitutional or had otherwise given a person a life sentence. Never had I done that.
Upon reflection, in the retention battle, what was your worst moment?
The worst moment was in Memphis. This is so telling, and I apologize for it, but every time I fly into the Memphis airport, I relive this moment, because it was at that little McDonald's in the Memphis airport. There used to be a McDonald's. I'm not sure it's still a McDonald's, and I can't even remember if it was cell phone or public phone, but I called Lyle Reed. I had been in Memphis for the weekend. There had been a huge festival on a Saturday, the kind of thing that people go to when they're campaigning. And I had all but been physically attacked. I had been verbally attacked over and over and over by everyone I would introduce myself to. Most of the people were confusing me with a federal judge in Nashville who had recently set aside a death sentence in a Kingsport case, the Gross Close case, that had been a death sentence that had been imposed like when I was in junior high. And they were like, how could you let that monster out of jail? And these people were really full of hate and anger. And I went back to the airport and I picked up the phone and I called Justice Lyle Reed, who was one of the 5 members of the court on which I sat. And I don't know, maybe, I don't like to think that he and I were closer, but we had a kindred spirit that was different. I had a connection with Justice Reed that was different than my connection with the other justices. And I just said, Lyle, it's over. You know, they are taking me down. And he said, oh, you know, no, they're not. And I said, look, I've run for office before. I know what it feels like when people look at you and you know that they would just as soon physically harm you as complete the conversation. But I was so very, very low. And I don't know why, but that is what sticks out in my mind as the worst moment, the moment when I knew this is it. It's not, and it may have been because I was alone, I was getting ready to get on a plane and fly home, but it was really a low moment.
Sounds almost strange to ask it, but during that whole process, do you have any good or maybe even funny memories of that time?
No, there's a heartwarming moment in it, and it relates to Judge Daughtry. So the election was on a Thursday, which is always true in Tennessee, and historically, maybe we'll change this by the time people watch this, but it's always in August, which is a low turnout anyway, unless you've got some sort of a really good primary, so judges have to worry about that as well. But I am pretty sure it was the Monday before that Thursday, but it could have been the week before. I was in my chambers in Johnson City, and in chambers there was only me and my assistant, Jan Archer, who was with me through my entire judicial career. My chambers was on the 2nd floor. There was no elevator. There were steps with rubber padding. So I couldn't see the steps because there was a wall, but I kept hearing steps after steps after steps, and I was, you know, in my office doing something, worrying, I'm sure. It was 3 or 4 days before the election. And finally, I just get up out of my office and I walk out and I look. And I go into the conference room, and there's a large conference table, and it is completely covered in yellow roses. Many in separate bud vases, some 2 in a bud vase, some 3, some 4, some even 6. Probably, I still have all the vases, probably 60 or 75 vases with yellow roses, all individually signed by people from all over, mostly women, all orchestrated by Judge Daughtry. And of course, the yellow rose is the sign of suffrage, and Tennessee being the perfect 36, the state that gave women the right to vote.
Got me wanting to cry too, so don't worry about it.
And there they all were. So that was a good moment.
Yeah, I'd say that was a good moment. After more than a decade has passed, in retrospect, what implications did your retention election fight have on the whole larger subject of an independent judiciary?
Well, you like to hope none. You like to hope there was no residual effect. All I know is what lawyers tell me. I'm not privy to many judge conversations. A lot of criminal defense lawyers, I mean, people laughingly say that they hope their case is, they want to get their case tried or on appeal not close to that 8-year mark. And there are a lot of comments, particularly with lawyers suggesting that they need to distance their cases from election year. But I've had two situations that were shocking even to me, and one was as recently as the judicial conference. Let's see, so the next race is 14, so it would have been 6. In 2006, I was back at the Park Vista in June speaking to the judicial conference on evidence. And that was the oddest feeling too, to realize I was back in that same building, the same exact day, except 10 years later. And more than one judge, and maybe this was just a figure of speech, but more than one judge would come up to me, "Hey, how you doing?" And I do have to say that they're much nicer to me when it's just judges around and there's no media around. But more than one judge said to me, "I'm just trying to avoid a Penny White episode." Now that scares me. That should never, ever, ever cross a judge's mind. I often said I was the best member of the court to be taken off because I did not have children. I did not have, we had certain members of our court had family members undergoing cancer treatment at the time, so we had people who had needed health insurance. Losing my pension, losing my salary, losing my health insurance was something I could deal with, but people with kids and health issues couldn't. So I often say that, so that I guess technically you would always think about, oh gosh, what would happen if I lose my job? But you should never be thinking about, I've got to rule a certain way to avoid a Penny White episode. That's very frightening to me. And the second thing is, and statistics are not always telling, but there has been a statistical study done about the amount of cases, the number of cases in which relief has been afforded, capital cases in which relief has been afforded by the 90 to 94 court, which was the new court when Chief Justice Reed, and then the 94 to 96 court, and then the post-96 court. And if you look just at the numbers, you could draw a conclusion that there had been an impact. I don't think looking at numbers tells you what the details of a case are, so I don't put that much faith in those cases or in those numbers. I have much more concern about the individual judges who will confess to thinking about how they rule in concern for whether they're going to stay on the bench. And so the overall, so that's the negative, and Penny White has a tendency to be negative. So let's go to the positive side. In 1996, the word judicial independence had probably never crossed my lips, nor maybe any of the lips of judges in this state. And in the 15 years or whatever it's been now, I personally have spoken in almost, it's either 38 or 40 states on the topic of judicial independence. And I know that the Tennessee judiciary has had that topic as a basis for its programs many, many times. So judges all over the country, because of what happened to little old me, have had opportunities, the judges who are going to be the tough judges and who are going to stay the course and do the right thing, to think about judicial independence and to try to get other members of other branches of government to think about it. So it has had a positive impact in some ways, and that I think we're talking about it, we're thinking about it, lawyers are supporting it, we're all thinking about the importance of the judiciary in upholding the rule of law, but it also has had that may have had that negative impact as well.
Well, at the time of this particular interview, a major battle continues between those who advocate a merit selection process and those who favor pure elections for judges, particularly the appellate bench. With the insight that you have gained from your experience on the bench and going through all this process, do you have strong opinions about that subject?
Well, I do, but it's not just as a result of the personal experience, because like I said a moment ago, personally, I might have won that election if I'd had an opponent. And can I just, as an aside, tell you that, or remind you, and let historians do the rest of the research, that at the whole time, maybe this is what you were just alluding to, Charles, and I misheard you. At the whole time I'm going through this election, I'm being sued by John J. Hooker, who's challenging the constitutionality of the Tennessee plan, and the Tennessee Attorney General has decided that it would be a conflict of interest to represent me. So I'm having to hire out of my own pocket a law firm to represent me, to defend me in Mr. Hooker's state and federal lawsuits. So this is all happening at the same time, and that was one of several precedents that decided that in fact a retention election system is constitutional in the state of Tennessee, which some present folks would like to sort of sweep those precedent under the carpet. But as a result of those experiences, but more so as a result of seeing what the United States Supreme Court's rulings, not only in Republican Party versus White, which I discussed a moment ago, but also in Citizens United, Federal Election Commission versus Citizens United, opening, basically saying that limits on campaign expenditures are unconstitutional. As a result of those two decisions, what has happened in election states is that the cost of judicial elections are skyrocketing. We're talking millions, 10, 12, 15, $20 million to run for a position that pays $150,000 or $200,000 a year. And so, cash is what determines who becomes a justice. And because of that, primarily, I don't see how, or I am convinced that we cannot maintain an independent judiciary if that judiciary is elected, particularly given those two decisions by the Supreme Court.
In 1996, the year of your retention election, you were the recipient of the YWCA Tribute to Women Award. You were the recipient of the Marion Griffin Award from the Association of Women Attorneys. And in 1997, the Bill of Rights Award from the American Civil Liberties Union. How meaningful was that to you at what had to be a pretty difficult time in your life?
Yeah, it helped. It was wonderful, obviously, for women to support me in that way, and for the ACLU to bestow that award upon me. And some of that time is a blur. I hope I express my appreciation to them as much as I should have, because hearing it put in the chronological context that you've done for me reminds me that there were still supporters out there, although I can say it didn't often feel that way. It felt pretty darn lonely, but I'm happy to be reminded of the chronology of that. It reminds me that things weren't as bleak as they seemed.
During this struggle, was part of it learning who your real friends were?
Yeah. Oh boy, it's something else. It is something. I mean, and by this time I was at the ripe old age of 40. I should have learned that before then, shouldn't I? I always say that my 40th birthday, that 40th year left a lot to be desired.
In your case, I'd say that was probably true.
The next decade was a little better, and maybe the next one will be even better. Who knows?
Well, let's talk about that. Since 1996, you had just an amazing career as a legal educator. Tell us what law schools you have served since 1996. Can you remember them all?
I sure can, yeah. I went to Washington and Lee, College of Law the first year, and from Washington and Lee, I went to the West Virginia University, and from there I went to the University of Denver, and from there I came to the University of Tennessee, and then for a short period of time I went to the University of North Carolina as a visitor, and then back to UT where I presently am.
You currently serve as the director of the Center for Advocacy and Dispute Resolution here at the University of Tennessee. Have you enjoyed that position?
It is just the best job. It is fabulous. It is a blend of teaching, administration, and serving. I want to call it serving the profession, because we do a lot of low fee, if not no fee, continuing legal education programs that are multidisciplinary, that bring together students and members of the profession, judges and lawyers, and in that way I feel like we serve the legal community, because particularly we gear programming to people who may be solo practitioners or people who may be in the types of practice that don't produce much revenue. So I enjoy it very much, and I love the teaching. My students are what make me get up every morning.
E. Overton was one of my very favorite professors when I was at the University of Tennessee, because he was just a delightful man. He was well up in his years when I was here, and just delightful and engaged in the soft shoe and a number of other things that kept students' attention. You are now the E. Overton Distinguished Professor of Law at the University of Tennessee. How do you feel about that?
I wish I'd known him, really. I never had him as a professor, and I never knew him. I've heard great stories, and I feel really honored to have the chair in his name. When I first started teaching, I said to myself, if they'll just let me teach, I'll never ask to be tenured. I can't aspire to that. I'll never ask to be tenured if they'll just let me teach. And then when I taught a while, I thought, well, I better ask to be tenured. And then I said, if they'll just tenure me, I'll never ask to be promoted. Being tenured will be good enough for me. But then my dean said, oh, you got to go for promotion. So then after I got that and they gave me a chair, I mean, golly, what else? That's just fabulous. But I have heard Overton's stories, and I wish I'd had a chance to know him and have his ability to create memories in his students the way he did in you.
I expect you do create memories in students, but probably not through the soft shoe.
Well, I do have my hearsay pie, which I think shall go without being explained.
All right. As you teach aspiring young lawyers in today's world, what do you view as your biggest challenge in trying to teach the art of advocacy?
The biggest challenge by far is the many challenges that is the challenge that is brought about by technology and by the how technology globally is affecting interpersonal relations. I mean, and by that I mean this. Advocacy is about the ability to connect with people, to connect with your client, to connect with the jury, to connect with the judge, to connect with opposing counsel, witnesses. And I fear and I struggle to help my students understand the importance of connecting with people, not connecting with devices. And it's really more than just the individual connecting with their device. It goes so far, it goes even farther than that. I mean, when we were in law school, Charles, we would bring a pen and a piece of paper or our legal pad, and we would listen and we would process, and then we might make a note. Or maybe people like me made several notes, because I did take a lot of notes. But what technology has done is it now enables the student to, what concerns me is that the students are using such technology that they're not listening or processing. They're transcribing verbatim. Now, and in that exchange, you got to fight to get that exchange in your classroom, because if you're transcribing everything and you're not processing it, yes, maybe you'll go process it later at home, but you might have had something wonderful to contribute to that discussion that never gets spoken or never gets responded to because you didn't process it. So, I mean, that's just one small example of just getting through to law students that advocacy is going to be about connecting with people. And you're going to learn a lot about connecting with people as you connect in the classroom. And of course, I don't want to say that it's not also about helping remind them that they are asking to become a part of a profession. not a part necessarily of a business enterprise. Yes, we hope they make a good living. Yes, we hope they're comfortable and so forth, and that they create, but it is a profession, and we struggle. I mean, some people would say, join the 2012's Professor White. It's no longer, it's not that anymore. But to me, those are the greatest struggles, to teach them that it's all about connecting with people. And really that is part of the fact that it is a profession, a professional endeavor. Now,
how do you do it? How do you limit that
not always
over-reliance
that well.
on technology?
No, not always that well. I mean, there's a huge debate in the legal academy now. Some professors ban laptops or ban all sorts of technological devices, and then others say, well, it's no different from, they're distracted by the internet. We were distracted by playing connect the dots or whatever. So I have not gone to those lengths. I try really hard to make my classes interesting, my lectures interesting, to not lecture, to engage. In the concentration which I direct, for which I select adjunct professors, many of our classes are 8 and 10 and 12 students. And so in those classes, I'm not at all afraid, or I don't hesitate to say, don't bring your laptop. Like I teach an advanced evidence class right now, and we sit around a conference table and we talk. And so in those classes, it's easier. But in my evidence class, which has 50-some people, there are people there. I'm sure that if I checked all their laptops from this morning, there would be a lot of them that were reading about last night's debate or checking ball scores or something. So it's hard. It is the challenge of modern day education, higher education, to keep students engaged. Now, sometimes we can use the technology to engage them. Most of us use technology in the classroom, either from as simple as slides and PowerPoint presentations, to use of clickers, where you ask the students a question and they click the answer, and then the screen shows their responses, so that they are interacting with technology. So I'm not just trying to say, technology is all bad, but it's a struggle.
Technology is our savior and our executioner.
That's exactly right.
So what classes do you teach beside evidence?
I teach evidence. One thing I'm really happy about is I've started and direct the judicial externship program here. We place, our first and foremost goal is to serve state court judges, and that was an outgrowth of a Knoxville Bar Association program. So we try to place students in state courts first, primarily here, the criminal courts and the Chancery Court, only because those are the judges who have shown interest. I've also begun placing students with the appellate courts, all the way up to the Supreme Court. We've had students in U.S. Magistrates Court and Federal Court. We've had students with the Tennessee Claims Commission. So the students work 12 to 15 hours a week in a judge's chambers, drafting opinions, doing other things that are helpful to the judge, and doing a lot of observation of how you act in court, and that in and of itself is a professionalism lesson. I also teach whatever else I need to staff, which could include, meaning that I don't have enough adjuncts, which could include and has included negotiations, interviewing and counseling, pretrial litigation, trial practice, professional responsibility. I don't teach that so much anymore. We have new professors who teach that. Criminal pretrial litigation, and a seminar sometimes on the media's impact on justice. I teach a little bit of everything, but all skills related. So my core courses are evidence, negotiations, trial practice, and the judicial externship.
Penny, you've had 3 amazing and successful careers.
Maybe that's why I'm tired.
You've been a lawyer, you've been a jurist, you've been an educator. Which of those is your favorite?
Oh, depends on the day.
Is it like asking you which is your favorite child?
Yeah, I guess. I don't know. I loved trying cases. I loved appellate argument in the Supreme Court. I loved trying cases. I love the trial bench, and I love some of the things about the Supreme Court, quite a few. I like teaching. I can't say, Charles. I've been so fortunate. So I've loved aspects of all of them. I used to say, and I do think this is still true, that I would be a trial judge again, and I would go to the Supreme Court again. I'd probably be a lawyer again. So I guess the only job I wouldn't take again, and my hat's off to them, is that poor, overworked intermediate appellate court job. So sorry about all the work they're having to do.
Well, we've learned about all of these things you have done in your career. What do you do outside the office? Do you do anything outside the office?
That's a bad one. Well, let's say what I like. I love the out of doors. I love the mountains, and I have a little place up on Watauga Lake, which I do not get to often enough. I have a large, extended family in the sense that my sister, I do not have children, I am not married. My sister has 4 children, and her 4 have a combination of 14. So with a little bit of it being yours, mine, and ours. So I do like spending time with my nieces and nephews. I have a few good friends that I love spending time with, and I love to travel. My present situation does not enable travel, the kind of travel I want to do. I mean, I really do want to see the world. I've seen a tiny amount. I've seen more of the world than I ever expected to see when I was in high school or college, but not nearly as much of the world as I want to see. And now I'm very, very involved in taking care of my parents. So that's really what's occupying my free time. I don't have much free time right now, but those are the things I would love to do. I like to cook. I'm not a gourmet cook, but I love to cook for people. I'm not a Southern cook either. I don't do biscuits and gravy. I don't do chicken and dumplings, but I like to cook for appreciative people.
Of all the places you've been in the world, if I had a short time, which one would you send me to? It's changed, but I love the Ring of Kerry and the Dingle Peninsula in Western Ireland. It's grown up much more than it was, but I love that. It's beautiful. Is there anything else you wish I had asked you that you'd like to tell us about?
Well, you kind of told me you might give me one thing, so there is one thing, and it's more for history. You know, we talked a little bit about selection, judicial selection, and I've mentioned a couple of times that the Supreme Court had boards and commissions. And one of the boards and commissions that I served on when I was on the Supreme Court that ties into the judicial selection retention thing that I think is so important is the evaluation process for judges. And I was fortunate enough to serve with now Justice Bill Koch when we first brought evaluations of judges, judicial performance evaluations to Tennessee. And one of the things that I would hope that history would remember is that Tennessee judges, when it was not something they really wanted to do, stepped up and said, yes, evaluate us. We want to be better judges. We want to improve. And there are 32 or 3 states where that is unheard of. There are only 8 states, maybe 10, where there's any kind of judicial performance evaluation. And so we hear a lot of rhetoric about judges being held accountable. The way to hold judges accountable is through meaningful judicial performance evaluations, evaluations that evaluate things that matter to judging, not which political party or which special interest group can give them the most money. So I hope, you know, as time goes on and people think about how do we select judges, how should we select judges, more and more people will embrace the idea of judicial performance evaluations, looking at, and this is not rocket science. I mean, there are a few states that have devised appropriate criteria to look at when you're trying to decide whether a judge is doing a good job. And I'm proud to have had some role in that, with Justice Koch obviously carrying the bulk of the work. He was the scholar on the commission, but I'm proud to have played some role in bringing that form of accountability to the state of Tennessee.
Is it your experience that with the judicial evaluation process, when the judge has the material made available to him or her, that they are willing to modify their behavior consistent with the evaluation?
Many, not all. I think we have bad eggs on the bench, just like we have bad eggs everywhere. And some people can't accept even meaningful criticism or as constructive and grow from it. But I think many desire that and want to know how to get better. So yeah, I think many do take that to heart.
My final question to you is, when all is said and done, how would you, Penny White, like to be remembered?
Well, I've thought about this, and that's a wonderful question. It's a wonderful opportunity to be able to answer that question, and I just appreciate the opportunity to make this tape. I hope that it is of some use someday. So how I would like to be remembered? I would like to be remembered as a person who always struggled to do the right thing, even in the face of grave adversity, who struggled to do the right thing. Maybe didn't always get it right, but struggled to do the right thing. And I'd also like to be remembered as a person of passion who when I had the opportunity, gave all I could to help enhance the integrity of the justice process, and have tried to embrace other opportunities to prepare others to fight to preserve the integrity of the justice process. And I guess lastly, as a compassionate person, as somebody who always treated everybody exactly the same, no matter who they were or where they were.
Great way to be remembered. Thank you, Penny. I've enjoyed this conversation.
Me too. Thank you.